Thank you, Nigel. Thank you to Blacknick and ARIN and CTU for inviting the department once again to be part of this event. Those of you who attended last year may remember that I participated in one of the roundtable sessions. But for those of you that were not here, I should clarify that even though my title is that of advisor and I'm based at the U.S. Embassy in Panama City, I'm not in fact diplomat. I'm a federal prosecutor, and I've been a federal prosecutor for more than 10 years, and I was a state prosecutor in California for several years before that. So the topics that I've been asked to address are going to come from that perspective. And I'm obviously going to share with you some thoughts based on the experience that I've had and that we've had in the US, and blending in some of the observations that I've formed over the years working in the hemisphere, because I work with and build capacity for law enforcement and judicial authorities throughout the Western Hemisphere. So even though I'm based here, I can and do work with authorities on different countries that are investigating some type of cyber crime, which you could understand basically is either a crime against a computer or, say, a crime against a person that isn't necessarily new, but is just being committed through new ways, through new technologies. And so they pose sometimes novel issues, though the crime itself is not necessarily new and it's not that difficult to understand. And then separately also on intellectual property crimes such as trademark infringement or copyright infringement, particularly as it involves the internet, theft of trade secrets. But obviously the focus of my comments now are going to be on that first bucket regarding cyber crime. And there are essentially three kind of takeaways that I want to leave you with, even though the specific topics for this keynote included cyber warfare or cyber terrorism. I'm essentially going to lump them in together with cyber crime because, you know, from my standpoint, they're just certain fundamental things that need to be in place in order to have a cogent response to any of them. And we should obviously be aware of the differences in those areas because they're there, but it's really not going to be important for this keynote to flesh those out, because what matters much more on a practical level is where the similarities are and how, if we appreciate those and we address those points, then we are, in fact, whether we're thinking of it that way or not, formulating a cogent response to incidents of all three kinds. So what are the three takeaways just up top? That any type of response for any country, and this includes the US, I'm not sort of directing this to any specific region, the hemisphere or any other hemisphere for that matter, you have to have a sound legal response, you have to have a sound capacity building response, and you have to have a sound industry response. And by industry, I'm not merely talking about private sector, but I'm also going to include critical infrastructure in here. And you may wonder why I'm doing that. It's because, as we all know, there's critical infrastructure that is entirely publicly owned, and then there's critical infrastructure that is not entirely publicly owned. And even where it is publicly owned, that doesn't mean that the government is actually operating that critical infrastructure. You know, it may grant a concession to a private party to actually operate that critical infrastructure. A perfect example here in Panama, where I live, would be a port, right? The port itself belongs to Panama, and Panamanian Customs obviously has, regulatory and certain enforcement responsibilities at that port, but the port is not in fact operated by Panamanian Customs. It is not operated by the Panamanian government, and instead it's operated by a third party, and that third party is private. And so I'm just going to include all critical infrastructure in this kind of industry bucket. So we'll go through each of those three, and then happy to answer any questions that folks have. When I talk about legal, I'm really talking about three kind of specific areas. And again, this is from my standpoint. One, you need to have statutes that clearly define what kind of conduct you want to prohibit. Now, again, part of cybercrime is just new modalities of old crimes. But to the extent that we have not defined computers as victims of crime, we have to. And I think that actually in a fair amount of countries in the Caribbean, that's not a problem. I think Barbados, for instance, is a Computer Misuse Act. I think Jamaica and a host of other countries in the CARICOM area already have some type of act or law that addresses criminal misuse of computers. Now, you can say that, well, some need to be updated or some need to be revised, but it doesn't change the fact that there is something there. And this is what is, I think, at least most significant, is that we have some legal basis from which police or prosecutors can say that they have a basis to act where there is an attack, whether it's against a user, a human being, a group of human beings, or a computer. Now, so part of that is statutory, right? But then again, looking at it from the standpoint of a prosecutor, you ultimately want to be able to vindicate any investigation with the prosecution if the target's in your jurisdiction, which means that you also have to have the opportunity, the ability to preserve and acquire evidence of that crime, right? Some of which is going to be technical, and this will feed into the industry discussion that I'm going to touch on again in a minute. But some of it is also in the possession of third parties. A common example may be evidence of a crime that's on a device that belongs to a suspect. Another might be a device that is on a server that belongs to a social network or a remote computing company. In the US, that could be Google, it could be Meta, etc. And so the question is, well, how are we going to preserve that unless that entity is already required by the law of the jurisdiction in which it operates to preserve it? And then how are we going to acquire it? And then what is kind of a separate issue, at least in the US, is how is that evidence going to be presented in court, right? Because we have statutes that define crimes, but in the US, we have rules of evidence in all 50 states and in the federal courts that actually govern how you're supposed to try and admit a piece of evidence, whether it's electronic or not, before a jury, right? So that also needs to be addressed. And what we've seen is that beginning with that last bucket, for instance, the presentation of evidence, it's very important to have practical rules of authentication, right? Before we can, for instance, argue that something is relevant or incriminates someone with a crime, if it's a piece of evidence, we have to be able to authenticate it. And so when it comes to evidence that may come, say, from Facebook or Google or any other company like that, we've adopted rules that basically allow us to, with just a written certification from the provider, establish that this is what it purports to be, so that there's no need to actually subpoena someone from the company, right? And so this is especially important for countries to consider where a lot of the providers that their DPP or their police force are going to for evidence do not have a presence in your country, because then there isn't going to be any way to serve them anyhow, right? At least in the US, I have the ability to serve with process someone from Facebook or someone from Google because they're American companies. But by the same token, it's very important for us to, in this area, also have laws that allow us to serve whatever entities operate within our jurisdiction, whether they're transnational or not, right? Because sometimes it's important to actually be able to serve an internet service provider, right, with process so that you can find out, well, who was subscribing or controlling a particular IP address on a given date and time that we suspect was involved in a network intrusion or some other type of illicit activity, right? The fact that, say, that crime may have occurred in Belize, just to give an example, but the provider is based in the UK, well, if they have an office in Belize, well, then they have to comply with Belizean law. They shouldn't be able to say, well, we're not actually from here, you know, even though we have an office here, even though we hire people here, even though we otherwise have to, you know, obey laws and pay taxes. We're kind of going to draw the line here and just say, well, we're not going to turn this over to you, and we prefer that you seek it through international means of assistance. Well, they shouldn't get to decide that. They shouldn't get to decide that. They don't get to determine what laws they want to follow and what laws they don't want to follow. And so I would strongly encourage all countries to really take a good look at whether or not they are regulating fairly but aggressively all types of internet service providers or electronic communication or remote computing providers that may be operating in their jurisdiction. Because if not, then that is essentially tying one hand behind the back of your prosecutors, whether you may know it or not. And indirectly behind the backs of prosecutors in other countries who may not be able to serve that provider anyway, because they don't have a presence in their country, they don't service customers in their country. I found that the Budapest Convention on Cybercrime is a valuable tool for helping countries kind of have a measuring stick of what best practices are in terms of addressing all of these different issues. Substantively, what cybercrime law should look like, what the rules of evidence should look like, what the procedural rules for the acquisition of evidence, including from suspects, should be, because you have essentially 80 countries, I believe, that have ratified the treaty from all around the world. And more importantly, they all share common values, I feel, when it comes to these issues. Values of due process, values of, you know, finding the right balance between security and privacy, guaranteeing people their day in court if they're accused of a crime. And so when you have those commonalities, you can in fact form a consensus that winds up working for everyone. Even though all the legal systems may be different, there are ways to kind of tease out principles and sort of not reinvent the wheel, and obviously have a say in where ultimately the world is going to go as new issues and new technologies develop. So we have always encouraged, and I know some of our foreign partners, Council of Europe, for instance, have been very energetic about raising awareness of the convention as a tool for countries that feel they're a little bit behind on where they should be on this front, getting caught up to speed. The G7 also has what we call a 24/7 network, and that it's available around the clock for preservation of electronic evidence. And what this does is basically allow a law enforcement officer in one country to contact his counterpart in another and request that evidence be preserved while they then prepare a legal process for the actual content, right? Because in the US, this is important. We don't obligate companies like Google to preserve any data, right? The burden is on us to ask for this. Not true in other countries, but in the US it is. And so if countries need our assistance with that, if they belong to that network, they can contact us directly. My section, Computer Crime and Intellectual Property section at DOJ, we're the central authority for that network, and we will handle the request, share the confirmation information so that you can then include it in your mutual legal assistance request. And unlike the Budapest Convention, that's not a treaty, that's a point-to-point arrangement. A police department or a public ministry would simply send in an application form, which I'm happy to share with any law enforcement agencies that are on the line. Kevin is free to share my email information afterwards, and simply sign up. It's not something that needs to be ratified. It's not a political document. It's just an understanding between law enforcement agencies in different countries that they're going to take reasonable best efforts to help one another with preservation and follow through. And then obviously share any insights on the provider. Maybe it isn't even worth it in certain cases. I've seen that also. We'll call someone, or I've received a call since being here in Panama from someone in the US that had a question about a provider that was based here. And after further discussion with our counterparts who were familiar already with this particular company, we just decided it wasn't even worth it because there wasn't going to be any information we'd likely be able to obtain, and there wasn't any guarantee they would notify the subscriber either of the request, right? Which in turn could jeopardize the investigation overall. So it's very valuable tools for countries to think about that I feel is of real value. And then, of course, in general, we also want to be requiring any of these companies on some level, whether they're internet service providers, providing communication or computing, or now increasingly services for virtual assets, right? Cryptocurrency exchanges, to know their customer and to share that customer data with regulators and law enforcement when we determine that their service is being used to facilitate some illicit activity, right? And then to see how those issues play out legally. So over time, we've had judges address the question of, just sticking with the cryptocurrency context, for instance, whether or not you could rely on blockchain tracing evidence as basis to obtain a search warrant, right? We've had to address whether or not we needed to modify our rules of federal criminal procedure so that we could go to any magistrate judge in the country and obtain a search warrant to send what we would call a network investigative technique to a dark web forum to try and find out who's running it, right? Because if someone's on the dark web, you don't know initially where they are, and traditionally you needed to go to the judge who had jurisdiction over the area where the crime was being committed. But if you don't know where the crime is being committed, there'd be no way to start. So we had to make a modification there. And we've also had questions raised by defendants sometimes after they've been convicted of whether or not, say, for instance, I have a reasonable expectation of privacy in my internet protocol address that the officers used to locate me. Therefore, a warrant should have been obtained for that. Is there a reasonable expectation of privacy in an internet protocol address or not? Right? And this is, I think, particularly important in Caribbean countries, at least the Anglophone Caribbean countries, where, I mean, as always in my experience been, our legal systems are more similar than with other countries in the hemisphere, because judges can make law, they will issue decisions that can bind, that are persuasive. And so you will sometimes have law essentially being made through cases and not merely through, an act of parliament. So those are my thoughts basically on the legal bucket. Capacity building, obviously, with new technologies, there's a need for people to stay up to speed on what the best practices are and tools are for all of these different types of investigations. And that's what I do. So again, if there's any law enforcement listening, Kevin can share my contact information and you can reach out to me. We work closely with all of the embassies in the region or consulates in the region. And so happy to discuss ways that we can assist you with that. But always with the caveat that as good as you may become with the technology, you should never use anything that you're not approved to by law. So that's why it's always important to kind of keep those two together. Yes, you want to know as much as you can, but you really want to focus on mastering the things that you're going to be allowed to use. And so you shouldn't use anything or try anything unless, say, a prosecutor has told you that that's going to be legal and a judge would approve it, because otherwise it's going to be counterproductive. And I want to finish in the minute or two that I have left for stressing the importance again of the collaboration with industry. And so I've talked a little bit already about the companies that will store data that we sometimes need to serve for process and how we need to regulate them, put them in situations where they're going to be helpful for us when we need it. I've talked a little bit about virtual asset service providers and basically the importance of requiring them to know their customers And this is an issue I think that maybe will surface in a lot more countries than you might think, because I've already heard sort of indirectly from contacts in other countries that they're trying to find a point of contact for a wallet service that's based in a Caribbean country, right? Now, it could be that they've just incorporated in the Caribbean country. But even then, it would be great to know that someone in that country knows, who is the attorney that represents that exchange or that mixing service or that online casino that accepts cryptocurrency that we think is being used to launder money. And what legal tools do we have to require them to turn over data to us, right? Are we basically going to tell them, for instance, that they can get away with just not turning anything over because they only have a lawyer? Or are we going to change the law so that we effectively impute to them all of the data and all of the servers of their company as if they were physically there, right? Not saying that that's what everyone should do, but those are the kinds of things that certainly from a law enforcement standpoint would help a lot. And so I would encourage DPPs and ministries of justice to really push the envelope maybe and to force those discussions because, there sometimes can be a trade-off between trying to make a country inviting for people to come and incorporate or to do business, but then at the same time, not really obligate them to make sure that the business they're running is clean, right? We don't want that either. So that's important to remember. And then lastly, I want to finish by telling you about a program that we just wrapped up here for Panamanian law enforcement, along with some of our colleagues at Homeland Security Investigations on first response to network intrusions. Because this is kind of a unique category. Until now, I've just been talking about companies as entities that will have some type of information that we need, and what are the tools and things that we need to do jurisdictionally and internationally to get the evidence from them that is relevant. And then obviously just separately about how we're going to present it in court. Here we're talking about companies as victims. And again, I'm going to include critical infrastructure and government ministries, although that may be slightly different. But I'm going to lump all of them in here just for purposes of making this point. Nobody wants to admit that they've been hacked. Nobody wants to admit that they've suffered a data breach, right? Because oftentimes they're going to be embarrassed and they're afraid that they may lose their jobs, right? So this puts us in a law enforcement standpoint already in kind of a difficult position. If we want to assist someone, if we feel it's our responsibility to assist someone with a hacking incident, we have to make them feel comfortable calling us. And that will require outreach, which is not something in this context that maybe law enforcement typically does, right? People are victims of crime, they'll come to us. We don't need to find them. This is different. This is different. Law enforcement has to do outreach. They have to learn how to do outreach. And they may very well require political assistance on this because, as I said, some critical infrastructure is in fact a mix of public and private, right? And not only in terms of operation, but let's say you may have a variety of different private cybersecurity vendors that are providing services of one kind or another for this ministry or that ministry or this agency or this part of critical infrastructure, whereas someone else is servicing this different part of critical infrastructure. So that you wind up with a quilt work of different entities that are all responsible for securing data in a system, but there's no evidence that they're talking to one another. There's no evidence that they're coordinating with one another. And there's no evidence necessarily that they're responsible to any one entity in government who can then obligate them to share information in a timely fashion in the event of a breach. So that requires a tremendous amount of support that in a lot of countries may have to come from the very top. Right? You may need an act of parliament. You may need a presidential or prime ministerial decree that says agency X is going to be responsible for responding to any attack against critical infrastructure as defined in this order or as defined in this act. In the US, we just did this a few months ago. We passed a law regarding cybersecurity that literally codified about 17 or 18 different categories of what we called critical infrastructure. And again, some of it public, some of it private. The bottom line is if you are on that list and you suffer a major cyber incident, which is also defined in the statute, you need to report that to our Cybersecurity and Infrastructure Agency, which is a component of the Department of Homeland Security, within a day. You're obligated to report it. And then they in turn are supposed to notify law enforcement, right? So that there's someone who's looking out for our equities, the law enforcement equities in these situations, right? Because these things are crimes. They may be incidents, of course, they have to be mitigated. But deterrence has to be a part of the long-term solution. It can't all be about mitigation. But that's not an easy message for law enforcement to sell on its own to a business, for instance, right? Because they may say, well, what's the likelihood that anything is going to be resolved anytime soon? How's that going to help me get back online? How's that going to help me respond to my customers? Right? So we have to figure out where, in fact, governments need to send a message that you need to care about it because we're telling you to care about it. And we will make you care about it because in the long run, it's going to make all of us safer and you as well. If you don't have any component of deterrence, then these attackers are going to know it and they'll just keep coming right back. And they will see how you're mitigating. And next time they will have some new workaround that you won't be prepared for. So do you want to keep playing, what we would call a game of whack-a-mole, or do you want to try and do something about it and catch the people who are responsible, especially if it turns out that they're in your own jurisdiction? Because with some critical infrastructure, it may very well be that the attackers are domestic, and it would be a shame to miss out on holding those people accountable simply because nobody knew who to call, nobody knew who was responsible, people were not sharing information, and we want to be prepared to avoid those types of things from happening, but it will require a lot more coordination and work overall between industry and government than is necessary to address some of the other points that I raised during the keynote. So I'm sorry I've gone over a little bit, but I want to thank you all again for the time and the invitation this morning. Nigel.
Thank you. Actually, the Q&A moderation will be done by Ms. Leslie Nobile of ARIN. And so I'll hand over to Leslie to interact. Leslie?
Great. Thanks, Nigel. Thank you so much, Daniel. That was extremely interesting. Really great to hear your unique insights and perspectives, especially given your position. So I'm going to open it up to Q&A, but I do have a question myself regarding the Budapest Convention. You mentioned that it's something that we've been paying really close attention to, particularly since the addition of the second protocol. I think it was signed in by the Council of Europe just a couple of weeks ago in May. And it's really obvious that the powers of law enforcement are limited by territorial boundaries. It's a ongoing problem, but it seems like this second protocol was designed to enhance the sharing of digital evidence. And I actually brought up just a sentence because I think this is interesting. It says the protocol provides a legal basis for disclosure of domain name registration information and for direct cooperation with service providers for subscriber information, effective means to obtain subscriber information and traffic data, immediate cooperation in emergencies, mutual assistance tools, as well as personal data protection safeguards. So this seems like all the things that are needed in order for countries to share information. What I did notice, I was watching the signing of it, is that I think only something like 22 countries signed it that day, whereas there's about 65 countries that have signed onto the Budapest Convention itself. So, I mean, what are your thoughts on this? How will this help with the sharing of information, digital evidence across countries?
I think it should help a lot because this was a recurring issue in conversations amongst the members over the last few years. And so the hope is that now information that in the grand scheme of things helps begin an investigation. A lot of different investigations will now become available sooner, which in turn enables people to use the capacity building that we give them sooner. Because one of the things that we always talk about is how to use that information once you get it to help establish attribution for your attacker. And yes, I mean, to a degree, you can technically begin those investigations through some good open source tools. But then once you've done that, of course, you want to be able to get behind screen isn't quite the right word, but you want to be able to then get in contact with whomever the provider is that may be controlling, say, the email account or the domain name, or that may actually have the content on one of their servers, so that you can then learn more about who actually is it that you're looking for. Mm-hmm. And kind of essentially get through the barriers that they've created, because on some level, it's in that sense that you could say these are like barriers. They're being used for illicit purposes so that people can get away with committing crimes, all over the world. And so the tools in and of themselves are not a big deal, but the way that they're being used is illegal, or it's facilitating illegal activity. So hopefully this just will make it easier for people to directly obtain, if they've already ratified the convention, data from a certain provider. And then in turn, that helps everyone, because we economize resources in a sense for international assistance that we're providing. Central authorities in other countries, similarly, they're less burdened. And the investigators and prosecutors that are actually most interested in that information, they get it faster, and they're able to just move things along till they feel like they kind of know who they're looking for.
Great. Just a quick follow on. So would this preclude a country from using the MLAT process if they are signed into this? Okay, so that's still going to be required. Okay, because it does take a long time.
I think that most countries that have ratified the treaty do view it as a mechanism through which you can formally request assistance. So if you didn't have, say, an MLAT, or and by that it could be either a bilateral or some multilateral treaty with which all the signatories agree to send each other evidence formally, the convention could serve that purpose. But it's always, I think, important to remember that people need to kind of confirm with their central authorities whether or not they even need to do that, where the information is merely going to be used for investigative purposes. I mean, I've always kind of thought of the MLAT as like roughly the equivalent of an apostille sometimes. And that if you want to use a document from one jurisdiction in another jurisdiction, you typically need to apostille it. Let's say if it was a birth certificate or whatever, because without it, well, that foreign government is going to say, well, I don't know that this is genuine. I don't know that this has been notarized by standards in my country. But if you apostille this, now I will accept it. Right. And so what happens is that if you want to take something into court and actually use it in a case against a judge, and it wasn't generated from within the country, right? It wasn't obtained through the powers of the court because it was extraterritorial. Well, then that's probably where you're going to want to use the MLAT, because that's going to be effectively like getting the apostille. Because when you get that evidence, it's going to come with seals and ribbons from the, say if it's from the US, from the Secretary of State, the Justice Department, and we'll have a whole series of things on it that will help convey to the judge that this is what it purports to be. Mm-hmm. Even though it's not from here. Even though I don't recognize the seal, I'm not obligated to recognize the seal. So that's why I just, for the law enforcement folks that may be listening to this, I guess, is to just always kind of double check and figure out whether or not you need that. Because if you're just trying to get information to advance an investigation, there could be a host of other ways of getting it. I mean, it could just be simple as calling up the phone, picking up the phone and calling the police attaché at an embassy that you've worked with before, saying, hey, by chance, have you looked into this? Or are you familiar with this? Especially in, the ransomware area, where, a lot of the attacks are totally transnational. And a lot of the most common variants are still being used regularly. It's possible that someone will come and report a case that involves one that no one has ever heard of, but odds are it won't be that way. So if you have the capacity to, work with the victim, they'll let you in, you get the information technically, you can share those logs, for instance, with, the relevant data with, a foreign police attaché, and they might be able to say, yes, in fact, this belongs to this family of ransomware. We have an investigation open to them, and this is where they think they are. Well, I mean, that saves you some time and effort. Of course, you're not going to be able to arrest them yourself, but at least you can go back to the victim and show some progress, on what you're doing, and that builds goodwill. So, but it's just important to kind of keep those strands separately, because where time is of the essence, it just may be better to pick up the phone.
Right. Absolutely. I do see that Nigel Casimir has a question, so I'll let him go ahead.
Yes, thank you very much, Leslie. Daniel, thanks for the very useful information, actually. I have two areas that I'd like you to elaborate on. Well, one clarification and one to elaborate on. The first is relates to critical infrastructure. Certainly a key objective is the protection of critical infrastructure. But from the legal point of view, does one have to define what is meant by that? And, is there any sort of specific definitions that must be developed? And secondly, relating to the capacity building side, if you could also expand a bit on the capacity building aspect that you mentioned, focusing on maybe who are the key stakeholder groups maybe we should be targeting, and what opportunities or strategies might be effective. Thanks.
Sure. So I think that the conclusion of the U.S. has been that it is good to define what we mean by critical infrastructure, because there are certain entities that, because of economic and national security concerns that a country may have, just have to be put in a special bucket. They can't simply suffer a cyber incident and not tell anyone quickly, because it will have nationwide repercussions, right? And a perfect example of this was the attack on the oil pipeline in the eastern US last year, right? It would have been futile, right, for that company to try and hide what happened, to try and mitigate that on their own, because everyone was going to know when they were not able to find gas at the station that something was wrong, right? And then it's in the interest of the politicians actually to do this, right? Because once it kind of bubbles up to them, they're going to be the last ones who can do anything about it, right? All they can do is say, well, I'm ordering that this be done, or I'm ordering that be done, but the damage is done. It's too late. It's too late. So I think that there was probably, after that incident, especially an awareness that what our own cybersecurity and infrastructure agency had been doing, I think, is a matter of maybe not even necessarily regulation, but guidance, needed to be codified. It was better for a government to simply say, hey, we're imposing upon you the responsibility of coming to us in the event that something happens. And we wanted you to do it within this period of time, and we want you to tell agency X. And agency X is then going to notify everyone else. Now, any country can pick, but it seems like the direction that I see a lot of countries going in is actually creating their own cybersecurity incident response team. And it may be in one ministry, it may be in a different ministry, it may be an autonomous agency. But what matters is different countries are creating this. And I think the idea is that they will eventually have this role. And so to help them be effective, right, for that to mean something more than just a piece of paper, you have to define who they regulate. And you have to impose penalties for whatever companies are going to be within their scope that don't collaborate. Right? And so there needs to be a discussion between the lawmakers and the people who are going to be in charge of handling the incident response on the ground level for that team. So a legislature could say, well, we're going to pass a law that says if you are defined as critical infrastructure, and I can share with you, the US did pass a law in March, a Cybersecurity Act that actually defined out 17 categories of critical infrastructure. Just to give you an idea, it includes hospitals, right? So it's not just, say, dams or, pipelines, right? But anything that could put significant number of lives at risk, right? A country's going to decide. There's no bright line rule. Every country's going to be different, and they're going to have to define, well, who do they want to put in this category? But what's important is that they define what it means to be in there, which should mean that if you suffer an incident, you need to report it to X. You need to do it within this period of time. And anything additional that the regulator told you would help them. Quarterly meetings to discuss the threat environment, proactively sharing reports of incidents of certain natures, right? Almost analogous to what we sometimes do with banks. In the US and in other countries, you may have, bank secrecy laws or bank, or maybe even it could be in anti-money laundering laws, but essentially requirements that financial institutions, for instance, proactively report certain suspicious activity. Maybe incorporate something similar for the critical infrastructure that you wouldn't necessarily for just a regular business, right? And say, hey, you need to come and tell us because our CCERT would like to have a heads up that you've seen an unusual increase in suspicious traffic so that we can get in ahead of time. Because once the incident has happened, it's too late. It's the best thing for an incident response team is to prevent the incident from happening at all, right? And so this is why, for a variety of different reasons, I think it is a good idea, and it is probably a good idea for this to come from the top down, so that this way every bureaucrat in government, every ministry understands that they simply can't do whatever they want because they're ultimately going to be accountable to one person who can sanction them if they don't comply, and they can get their house in order. Because this is not saying that you can't have a private vendor do your cybersecurity services, but if, for instance, you have them sign a non-disclosure agreement, well, there should be an exception for the CCERT, right? When the CCERT is enforcing local law, you're not going to then say, well, we don't have to share information or who are you or anything like that. It can't happen, right? It can't happen. And on the capacity building side, our main audience, of course, is typically prosecutors and police. Although because of the growth in the use of cryptocurrencies to commit crimes, we've also done a lot of capacity building for analysts of financial intelligence who may not necessarily be in a police force or a public ministry, but like kind of work with them or in parallel to them, enforcing some other kind of regulation. The forensic analysts, of course, that will seize and analyze devices. And where network intrusions are concerned, we've also invited CCERT personnel to come to, say, our programs, not so much because they need the capacity building. They tend to be people who already have a background in systems. And so some of the terminology and issues that surface are going to be well known to them, but simply because they may be required to essentially protect the equities of law enforcement in an incident. So they need to know what are the things that law enforcement is going to want before certain mitigation steps take place that could alter data or delete data inadvertently that might have helped begin an investigation, right? So you want to involve them a little bit in the capacity building, at least insofar as the network intrusions is concerned, because the way that a country may approach this, it's going to be multidisciplinary. You're not necessarily going to have a police officer responding first. You could have a systems engineer who works for the CCERT, but that person has to have in the back of their mind the understanding that, yes, you're going to try and help mitigate, but you have to balance that against the interest of the law enforcement officer who isn't there yet to know what happened and who's responsible. So you have to talk with the IT people or the information security people at that entity to make sure that whatever they're doing is not deleting or altering something, at least until police can get there with their cyber forensic people, capture what they need, and they'll be on their way, right? The capacity building is focused on
I
the
think
job.
Leslie's trying to get your attention.
Sorry, my apologies. I have to interrupt. I hate to do this, but we do have to wrap the session up right now. I've been sort of given the warning. So I just want to thank you for all of your information. It was fascinating and extremely useful, I think, to this audience. Thanks, Daniel. I'm going to
Thanks so
turn it over. Thank you.